In the second clip on the African system, I want to go a little bit more systematically through the various legal instruments as well as bodies, and that includes most notably, of course, the African Commission and the African Court on Human and People's Rights that create or that make up this system. I'll also briefly address the question of the shortcomings or problems that confront the African human rights protection system, most notably when it comes to the question of political will. As explained in the previous video, the legal basis for the African human rights system is, of course, the Banjul Charter of 1981, which also has two protocols, one of which I have already mentioned, namely the 1998 protocol establishing the African Court on Human and People's Rights. Next to this, we have a protocol from 2003 on the protection of women in this system. And there are also two separate human rights instruments that should be mentioned, and that includes the 1990 African Charter on Children's Rights, as well as the 1969 Regional Convention on Refugee Protection that obviously predates the system, but has by now become an integral part of it. This almost completes the organizational chart, but not quite, because we do have to mention the 2000 Constitutive Act of the African Union, which creates various political organs and most notably the African Assembly of Heads of Government and Heads of States, which both elects the members of the Commission and also receives the reports of the Commission related to human rights issues and situations in various countries. The Assembly also nominates the 11 judges for the African Court. And it should also mention that the African Court of Human and People's Rights is supposed to merge or be replaced by an African Court of Justice. This, however, has not yet happened because only 7 out of 15 states have ratified the protocol that is supposed to bring this change about. Let's zoom in for a moment on the African Commission on Human and People's Rights, which consists of 11 members that are serving 6-year terms in their individual capacity and meet twice a year to discuss various topics and fulfill their tasks, which includes most notably the receipt and review of individual communications, which can then actually be forwarded to a court. It also includes the appointment of special rapporteurs and working groups that will address a particular human rights situation, especially in a country that is in crisis. And it also includes the possibility of on-site visits in a particular place, although the African Commission has been more reluctant than the Inter-American one to make use of this possibility. What's different from the Inter-American system and more resembling actually the UN Human Rights Treaty bodies, and as also explained in the textbook, is that the Commission receives and reviews state reports as well, which are continuous, and this is obviously something that we know more from the UN system than from the regional systems. So this is in fact one of the unique and specific characteristics of the African system. Last but not least, the Commission also submits an annual human rights report to the African Union Assembly of Heads of States and Government. Next to the Commission, we have the African Court of Human and People's Rights, again consisting of 11 members or judges in this case that serve for a 6-year term that is in principle renewable for 4 years. The court has its seat in Arusha and meets 4 times a year, and in fact, except for the president, the other 10 judges are part-time, and already this fact makes us expect resource constraints and constraints on the workload that, as we'll see in a second, are in fact there. The court has a very broad jurisdiction which includes not only the Charter but also other relevant human rights instruments, and that includes at the very least the Charter on Children's Rights that I have mentioned before, as well as the Protocol on Women's Rights, but potentially also other treaties including UN treaties. Nonetheless, the court actually issued its first judgment only in 2013 and has been able to hand down only about 24 judgments overall, which is far less than what the Commission is doing. So the profile of the court despite the potential of its jurisdiction, is in fact rather limited, at least at this point in time. And this brings us yet again to the limits and shortcomings of the African system, which I would like to address here. First, as we can see from this discussion on the court, not only does it lack resources, but there's also in fact an additional barrier to direct access to the court. In fact, in order for an individual to have direct access, a state needs to make an additional declaration that allows for such a possibility. The Commission has also had some experience with attempts at political interference, which includes the issuing of a code of conduct, as well as the rejection of observer status to particular NGOs, and in general a challenging of the independence of the Commission. Both of these problems reflect a challenge of political will on the part of state parties to really take their human rights obligations seriously. And another very visible manifestation of that are the so-called clawback clauses that are presumably contained in the Charter. What is meant by clawback clauses? Well, these are limitations to specific rights, which we have obviously discussed in previous sessions, and these are obviously quite common. However, in the case or in the context of the African Charter, they are extremely broad because they only hold that a limitation needs to be provided by law. Basically, taking away the two requirements of there being a legitimate goal and them being proportionate. And you can see here how without those two additional elements, a state party is obviously pretty much free to implement any sort of limitation that it wants, as long as it provides for it through legislation and by legal means. Now, the Commission has pushed back against such a conception, and this is very commendable. In 1998, it in fact did establish that both a legitimate state interest as well as a proportionality and necessity requirement were actually implicitly a part of the Charter system because, as it argues very rightly, otherwise the whole system or framework would be useless from the get-go. And finally, of course, the lack of political will is really reflected in the fact that there's often inaction on the part of African Union states when it comes to gross and even systematic human rights violations in places like Burundi or Sudan, or most notably recently Ethiopia and Eritrea, where massive violations are not in fact given the attention and reaction that they should receive from other neighboring and other states in the African Union. Of course, the lack of collaboration of African states with the ICC, something that we touched upon in the course on public international law, is another manifestation of the same lack of political will to really improve things on the ground and implement the rights obligations duly. This concludes the two short clips on the African regional system, and I look forward to discussing the topics with you in class.